May I praise the Lord?
Yes.
I beg to mention item number 21. Also, kindly take up this matter after 1 week.
Have you given your mention slip?
No,
Why?
actually, whatever, I just today morning itself I got the one new documents from the petitioner. So I want to file an additional affidavit.
Your good name?
J. Paul.
On request made by MSG Paul and counsel for petitioner and list the matter after
1 week.
1 week.
Comprehensive.
May I please? I
Yes.
beg to mention item number 24, my lord.
Here also no mention slip.
No.
Why these things are happening? I've told you before,
I have informed the suspect, my lord.
whatever it is, you may have informed, but then you're supposed to give a mention slip 24 hours earlier. I'm giving you adjournment today, but after that, I'm not giving you for Yes, what is your prayer?
List after 1 week, my lord.
You're Mr.
M. Shalim.
On request made by M. Shalom, list the matter.
Item 24.
Learned counsel for petitioner.
Item 1 of daily list, motion.
Item 22, there's an adjournment slip, isn't it? And they're not mentioned.
May
Yes.
your lordship.
Yes.
My lord, here in this case, my lord, there is a shifting of from one village to other village, from Udiret Sor to Monakusha. My lord, we got the documents, my lord, relevant documents. We will file an additional affidavit. My lord, I may be given this short time, my lord. We got the documents, sir.
Okay. Mr. Shiptal and counsel for petitioner is allowed. How much time?
My lord, 1 week time, my
1
lord.
week time to file an additional affidavit. List after 1 week.
Deep lovely, lordship.
2,
Lordship, kindly pass over the matter for time being.
Why?
My senior is engaged with
Who's
another
your senior?
G. Bora.
G for. Okay, after some time.
3,
May I please, your lordship?
Yeah.
In this case, lordship, my father's name is Idris Bepari, lordship. And his name is in the voter list of 1971. Page
Page-
21, lordship.
Oh. Idris Bivari.
Idris Bepari, page 21.
Yes. Sadhu,
Sadhu.
your grandfather.
No, my father, grandfather, lord.
Oh.
My grandfather.
Then
And my name is reflected in the voter list of 1985, lordship, page 22. Razia Begum.
Jainal.
Razia Begum. My husband name is Joinal, lordship. In this case, lordship, I have filed written statement as well as lordship evidence and affidavit.
Hmm.
Written statement at page lordship 15. 15.
Yes.
15 to 20, lordship. Actually, what happened, lordship? Kindly see, lordship, page 15A, lordship, paragraph 3. The true state of affairs, lordship. This is the thing, lordship, what happens.
Maybe.
Page 15. সেটা এড করে দিছো 8 পয়েন্ট মানে টাইপ লিখা এগুলো মানে পেজটি ভালো আছে টাইপ মানে টাইপ করে দিছো মেন কবিতা আছে
Yes. What's your opinion?
Opinion at page lordship, opinion. At page 11.
11.
11. Page 11. Start from page 11, lordship. Annex 1.
Yes.
In this case, lordship, I filed a written statement lately, lordship, and that is why, lordship, without hearing me, lordship, this judgment was passed.
It's an ex parte order.
Ex parte order, lordship. Ex parte order. Without hearing me, lordship,
But he appeared, lordship.
but I appeared, lordship, but lately, lordship, I appeared. That is why, lordship, court below, lordship, passed this order.
Lordship, case 13, lordship.
13.
Page.
Page 30, page
13, lordship.
13.
Okay.
Page 13, lordship, the last paragraph, lordship, kindly see, it is pertinent to state that the period of first lockdown, that is March 2020 to October 20, again January 21 to October 21, that is the period of first and second lockdown due to COVID-19.
Where you're reading from?
Lordship,
From page
page 13, lordship, page
13.
13, last paragraph, lordship,
last
paragraph, lordship. I'm reading, lordship, the relevant portion. It is pertinent to mention here the period of first lockdown, that is March 2020 to October 2020, again January 21 to October 21, that is the period of first and second lockdown due to COVID-19 has not been taken into consideration while passing the order. Prior passing the order, that is the tax lodge. That portion was not considered. Thereafter, this order was passed.
What is your link to your father?
What link, lordship?
How do you link to your father?
I'm coming to it, lordship. In page 23, lordship, I himself said that this paper is my father. Page 23, evidence and affidavit. Page 23.
Okay, this is a different thing, but do you have any other document?
Any documents, lordship? Page 27, lordship. Kindly say. Page 27. That is, lordship, certificate. Office of the Secretary, Removed Road, Gaon Panchayat. This is certified Razia Begum, daughter of Idris Bepari. So my only humble prayer, lordship, I may be protected, lordship. I'm a lady, and call for the LCR, lordship. That is my only humble prayer, lordship. I may be protected, lordship.
See, the order was passed ex parte
That's it.
without going into the merits.
Lord,
Correct?
Lord,
Now, what is the issue? Point of calling for the LCR?
the remand back the
So,
case.
COVID period started from March 2020, lordship, and petitioner absent since 2018, lordship. Where are 13, lordship, on perusal of the first paragraph. Only children. I'm looking.
Yes. Sharma? We sent it back.
Lordship. Some
Sure.
cost may be imposed, lordship, due to conduct of the petitioner, lordship.
It is up to your lordship.
What is the petitioner doing?
It lordship petitioner is the lordship daily wage earner lordship. The illiterate lady lordship. Illiterate lordship due to illiteracy lordship. Whatever council said, could the court below. They are taking into account those things and they could not appear.
Hurt Mr.
A Sharma.
A. Sharma, learned counsel for the petitioner. Also heard MS L. Devi, learned CGP for the respondent, 1,
and 6 lordship.
1 and 6. Mr. AI Ali, learned standing counsel, is here for respondent number 2. Mr. G. Sharma, learned standing counsel, FT
3, 4, 7.
for 3,
Seven.
4 and
3, 4 and 7.
7. How about 5?
Both type lordship. A civil appeal lordship. Election commission. For registration office. Oh, I'm appearing lordship.
5 also, huh? And Mr. P. Sharma, then a description of the respondent. Stop. On a reference being made against the petitioner oblique proceeding. With regard to her nationality. Comma. FT case number NFT within bracket numbers stop 3 within bracket D 231 oblique 2015 was registered before the Foreigners Tribunal, Perth, Nowong, Assam. Stop. Notice was issued to the petitioner, and in response, the petitioner appeared through her counsel before the tribunal on 5/7/2017. Stop. Petitioner also filed her written statement. Stop. Draft, comma, from 29/11/2018 to 11/3/2020. The petitioner could not only file petitions, praying time for evidence, but could not adduce any evidence. Stop. Draft, comma, from 19/3/2020 till 29/4/2022. Neither the petitioner nor her counsel appeared before the tribunal. Stop. Accordingly, comma, the learned tribunal by an order public opinion dated 25/4/2022. Plus an ex parte order. Holding that the petitioner as a foreign national oblique illegal migrant of post 25/3/1971. Stop. Para. Learned counsel for the petitioner supports. What is your ground? Why do you didn't appear?
Personal difficulties, lordship.
What personal difficulty on so many occasions? What is your personal difficulty? Submits that the petitioner could not appear before the tribunal due to personal difficulties. and therefore prays for one last chance to enable her to appear before the tribunal. And thereafter, the proceedings, before the tribunal for proceeding with the aforementioned case stuff. But after considering the materials available on report, as well as the submission made by the learned counsel for the petition, comma, the district petition is disposed of by remanding back the matter to the learned foreigners tribunal, third Nagaon, Assam, to hear the petitioner and thereafter pass appropriate orders in accordance with the stuff. Para. Accordingly, comma, the ex parte order oblique opinion dated 25/4/2022 passed in FT case number NFT within bracket number 3 within bracket D 23/1/2015 passed by the Learned Foreigners Tribunal, third Nagaon, Assam, to set aside the question. Stop. The petitioner shall appear before the Foreigners Tribunal, third Nagaon, Assam, on
Any, within 15 days, Lordship.
29th of September 2022.
Yes.
With the apposite, the petition is accordingly disposed of. No LCS. No LCS.
Obliged, Lordship.
Or.
May please, your lordship kindly pay his order dated 9/8/2023.
Lordship, thank you.
Yes,
Yes, Lordship, regarding page 41, Lordship. Lordship, there was no marriage registration found, Lordship.
no, but you are directed to produce the marriage
Yes.
register, isn't it?
Yes. Yeah.
Have you got a copy?
Yes.
Now this is going to be a big problem. Now you can't read, no?
Regarding page 41, there are no
Is
records.
it in
Lordship.
vernacular or in English?
Next. Original.
Yes, there's no marriage.
Lordship, matter may come up on Monday, Lordship. I am to obtain instruction in that case, Lordship.
That's not always there.
We should get started.
I think it's a manipulated document, Lordship. And probably said everything.
Okay. Mr. P. Sharma, the additional senior governor, has produced the marriage register. Marriage register of what? Which area? One. Let's take the one. The Muslim marriage list of Golbara district.
Yes.
Of Golbara district. Stop. He has also produced a letter dated 19/8/2023, written by the registrar, Muslim Marriage and Divorce, Jaliswar, Golpara, addressed to the district magistrate Golpara, wherein it is stated that he has not registered the marriage of the petitioner, correct? Petitioner. Stop. MS,
F Intaz Lodge.
if in the when the council for petitioner. Place for some time to enable her to receive instructions. Please the matter again after
Next week, Lordship.
1 week. You retain it. Retain the file.
File.
Okay.
Return no editing. Please, your lordship. My lord, here in this case, my lord, there is an order of this honorable court to, it is the inquiry report, status report, my lord, that has been awaited. But, my lord, otherwise, my lord, my case is established by the documents and the evidence additional. My mother was examined, my lord. And my grandfather is in voter list of 1966-70.
1 minute.
National report,
Yes, have you got the inquiry report,
Lordship,
Mr. Sharma?
Dinath will dealing with this case, Lordship, regarding CID report, Lordship. For the time being, passive verdict method.
Okay, after some time.
Six.
May I please? This.
Sir.
Inquiry করবো।
Inquiry করবো।
আমরা করি সেটা।
DCP.
একটু তো। একটু time লাগে। This is also regarding CID report, Lordship. For the time being, sir. না, এটা রবি সরকার তো এটি মনে হয় তো রবি সরকার
Nadia.
Nadia Kasmi.
Lordships,
Any report?
no, we have not received a report, my lord. Actually, petitioner original from Nadia, West Bengal, my lord. So we have not received that report. Sometime
What MS,
MD Medhi.
MD Medhi, Learned Council for the petitioner. Mr. P. Sharma, Learned Petitioner, Senior Governor. Is allowed another 2 weeks time. 2 weeks time to enable him to produce the report as directed by the spot on 17/8/2023. Please after 2 weeks.
Obligations. Documents.
May I please, your lordship,
Uh,
let them at about timing, lordship. Seven.
Mm,
Yes,
Timing lordship,
why?
because lordship my senior lacking the court number 22 lordship. After some time.
Eight,
My lord. My lord, on the last occasion, a report was sought from the Deputy Commissioner Morigaon, my lord.
Yes,
Some time, I have not received that report. Send letter. Another 2 weeks time. What is that?
but Mister,
A.W. Aman. My lord, in the meantime, interim may be considered.
you interim is the,
My lord, the last order says no coercive action to be taken against the till the next date.
so,
That may be extended, my lord.
but Mr. A.W. Aman, learning counsel for the petitioner. On request made by Mr. P. Sharma, learned additional senior government. 2 weeks further time is allowed to enable him to produce the records as directed by this court on 21/8/2022. Stop. List of the 2 weeks interim order passed earlier to consider.
Deeply obliged. my lord.
nine,
May I please, Lord? My lord, there was a selection for the post of good guards in the NFL railway. My lord. When the selection was, my lord, conducted and select list was prepared for 19 candidates, there were some irregularities that has been, my lord, alleged, and malpractices were also there. And for which vigilance inquiry was, my lord, conducted. And after conducting the vigilance inquiry, my lord, the select list has been cancelled. Lordship may kindly find the order of cancellation of the select list at page 41,
This is a division bench matter?
my lord.
This is a division bench matter.
My lord, this is my lord, against the, my lord, judgment and order passed by the learned, my lord, central administrative.
Okay. Then,
And my lord, when this death has been cancelled and fresh inquiry was directed to be conducted, that was at my lord, page 43. Then, my lord, the candidates who were selected, my lord, approached the Honorable Central Administrative Tribunal. And the Central Administrative Tribunal has passed an order which is at page, my lord, 47. The candidate who were selected in the selection process, they preferred this original application. And that original application has been, my lord, disposed of by the Honorable Central Administrative Tribunal only with some technical grounds. Page 62 is the operative portion of the judgment, my lord. Because Central Administrative Tribunal hold that no opportunity to defend the applicant who were selected, my lord,
page,
page 61 is the operative portion. of the direction. The respondent are further directed to take appropriate step as per their own railway board circular, as well as the settled principle of law. My lord, that has been set aside only on the ground, my lord. There was no opportunity was given to the applicant.
Let us see.
Page 60, my lord. Paragraph 15. From the perusal of the above circular, it is noted that Railway Board had already taken care of the various judgments passed by the different tribunals, high courts, as well as Honorable Apex Court on the same issue, and had issued the said circular directing that even if it would be found that whenever selection process are required to be cancelled after declaration of the result due to procedural irregularities, malpractices, due notice should be given to the candidates declared selected. However, in the instant case, also applicant were declared selected by result dated 2/7/2021. Whereas admittedly, without granting any opportunity, the respondent had cancelled the said examination by order dated 9/9/2021, even without assigning any reason, and subsequently had published the new notification for the same vacancies on 10/9/2021. Therefore, in our considered opinion, such cancellation of the earlier result without granting any opportunity of the applicant is liable to be quashed and set aside. And that is why, my lord, that has been cancelled. It is not the case, my lord. Honorable Tribunal has, my lord, declared that cancellation is paid. My lord, what that authority, because, my lord, this is a quarrel between the, my lord, beneficiaries and the, my lord, authority who conducted the malpractices. That is why, my lord, both the parties, the applicant and the respondents are in the same footings. And they, what they have done after taking the handle of this, my lord, order, the page 62 order has been passed. In the matter of OA number so-and-so, Shri Sudhir Kumar Singh and 14 others, Honorable CAT Guwahati by its order dated 24/1/2023 has quashed and set aside the cancellation order of the selection for the post of good guard in level 5 against 15% LDC quota by this office note number so-and-so dated 9/9/2021, resultantly impugned press notification dated 10/9/2021. Next paragraph is very important. In compliance of the Honorable CAT Guwahati related to facts and circumstances towards implementation of the court's order, the empaneled candidates are entitled to be promoted to the cadre of good guard in level 5 on the basis of the selected panel published by this office memorandum number so-and-so dated 2/7/21. My lord, what they have done in compliance of the CAT's order, my lord, they have declared that, my lord, the selection panel is valid. Without, my lord, issuing any notice to the selected candidate because of, my lord, rampant, my lord, irregularities and illegalities, and it has been established in the vigilance inquiry. They have done that the select list is valid. As per the direction of the Honorable Tribunal. Tribunal has not directed that, my lord. Tribunal direction was, my lord, to follow the procedure and giving them opportunity, my lord, that has been done. That may be done. Well, that is why, my lord, that has been set aside and quashed. Thereafter, my lord, the person, the present applicant, challenged these orders in OA number, my lord, 40/23, and there was, my lord, specific case of the present, my lord, petitioner was that, my lord, page 67 is the order passed in the, which is impugned here in my lord. My lord, the case of the present petitioner was very specific. The vigilance inquiry is required to be, my lord, placed before the Honorable Court. The answer sheets of the, my lord, selected candidate, as well as the petitioner, shall be placed before the Honorable Tribunal. But the Honorable Tribunal, without going through, my lord, through all this, my lord, documents, only on the basis of the consolidated statement of the marks of the candidates, my lord, dismiss this original application filed by the present petition. And against the said, my lord, order, my lord, this said petition is preferred. The operative portion of the said judgment, your lordship find that, my lord, page 76. It starts from page 67. Only on the basis of the marks of the petitioner as well as the, my lord, selected candidate, this has been decided. And no other, my lord, relevant, my lord, vigilance inquiry, answer script, etc., that has not been placed before the honorable court. Page 67, paragraph 9 and 10.
Yes.
My lord. Yes. As such, my lord, my humble prayer at this stage, my lord, lordship may kindly issue notice and lordship may call for the entire records of the selection as well as, my lord, answer script of the, my lord, selected candidate as well as the petitioner. My lord. That was the prayer made before the learned tribunal. My lord.
What is wrong in para 9?
Para 9, my lord, only on the basis of the marks obtained by the petitioner as well as, my lord, the selected candidate, that has been decided.
How many applicants were there?
Total applicant, I cannot say, my lord, but they from the panel, it was of 19 and 20 post was advertised.
No, no, no. Only a sole applicant was the petitioner in
Yes,
the
ma'am.
OA 40.
My lord. OA40 is the sole applicant,
So what does it say in para 9? Just read it.
my lord. From the perusal of the tabulation sheet, it appears that three candidates, namely Shri Binod Kumar Rai, Shri Navin Kumar, and Shri Niraj Kumar Jadhav, all are all UR candidate, my lord, unreserved category candidate, and the petitioner herein is the unreserved category candidate, against whom applicant alleged to have got lesser marks in the written examination have got 81, 85, and 85 marks respectively, whereas the applicant got 78 marks only. All the candidates who were declared passed and recommended for the panel secured more marks than the applicant, and the last selected candidates under your category got total 65.5 marks, whereas the applicant, unreserved candidate, got total 63 marks only. Even the applicant scored lesser marks in the written examination than those three candidates named above. It is further observed that candidates recommended under your category got higher marks than the applicant and were empaneled. What is wrong in this, my lord, paragraph is that the honorable tribunal only perused the, my lord, mark sheet, on the consolidated mark sheet. They did not, my lord, go through the, my lord, answer script. It was the specific prayer before the honorable tribunal by this petitioner.
Is it necessary to go through?
Yes,
the
my
answer
lord,
script?
because, my lord, there was a vigilance inquiry and it was established from the vigilance inquiry that there was rampant illegalities and irregularities. That is why, my lord, that selection was cancelled. But the honorable tribunal in an earlier round of litigation between the, my lord, selected candidate and the authority, my lord, only observation of the tribunal was, my lord, no notice was, my lord, given to the selected candidate. That is why you follow the guidelines of the railway authority and give notice to them and then cancel. That was the direction. But in compliance of the direction passed by the honorable tribunal that has been stated in the impugn order, my lord, the selection panel was found to be valid. That was the, my lord, decision of the authority. And that was, my lord, stated to be, my lord, as per direction of the honorable tribunal. That was not the direction of the honorable tribunal. Because, my lord, illegalities and irregularities in the selection process has been done by the authority who is respondent hearing. And the beneficiaries are also respondent hearing. And they were the same both brother. And taking handle of the, my lord, honorable tribunal's order while setting aside the, my lord, the cancellation order, my lord, remanded the matter back to the authority to initiate a process after giving the notice to the selected candidate. That should have been done. But instead of doing so, what they did, as per direction of the Honorable Tribunal, selection panel is found valid. My lord, in the said circumstances, the vigilance inquiry, more particularly the vigilance inquiry, is very much necessary to adjudicate this matter. my lord. And the answer sheet.
Yes,
My lord, in this regard, my lord, the instruction is necessary, my lord. They are saying that the vigilance inquiry was there. Whether it is, there was a vigilance inquiry, this instruction is necessary, and they have implemented the beneficiary, the private respondents. And notice may go to those beneficiaries.
but Mr.
D.K. Sharma.
D.K. Sharma, let me consider. Issue notice. You are praying for
Respond number 1 to 4.
Mr.
1, 2, 3, 4.
Mr.
My lord, Vicky Datta,
A.K. Datta, Leonard,
CGC, my lord.
CGC. Enters appearance on behalf of the respondents, 1, 2, 3, and 4.
1 to 4.
1 to 4. my lord.
Oh, 1 to 4. Petitioner to take steps for service of notice. And the respondents, 5 to
5 to 21.
by registered post daily. Within a period of 1 week,
My lord.
1 week.
And lordship may observe, my lord, pendency shall not be barred to consider the prayer of the writ petitioner.
List the matter after 4 weeks. Pendency of this writ petition shall not be a bar for the respondents to consider the case of.
Obliged.
Item 2,
No, please, your lordship.
Uh,
Lordship, it's a contested case, lordship, and the interim order is case number, lordship. 44, lordship,
Page
44, lordship. Interim
34.
44, lordship. The case in brief, lordship, due to not establishing linkage with my projected further, lordship.
Page 34 is
44, lordship. 44, lordship.
yes.
The relevant portion is at lordship 45, lordship.
Uh.
I'm reading the relevant portion, lordship.
Uh.
I have produced written statement, evidence on record, and all exhibited documents very carefully and found it. The proceedings have stated that his father's name is Hassan Ali and grandfather's name is Ali Mia. And accordingly, he has provided a sale deed of the year 1961, but was unable to prove that he is the son of Hassan Ali by adducing reliable documentary evidence. DW2 has stated that the proceeding is his elder brother, but he too failed to prove that he is the son of Hassan Ali by adducing reliable documentary evidence. The proceeding has completely failed to prove that the Hassan Ali is the father residing prior to the year 1971 by adding proper linkage document. Although he has claimed that he had casted his vote in the year of 1985, but he was unable to produce any document in support of it. He has also clearly stated that his father had been casting votes in 1979 until his death, but was unable to exhibit the same. Though the proceeding has proved the sale deed of his projected father, Hassan Ali, but he was unable to prove that Hassan Ali is his father by adducing reliable documents. Moreover, the proceeding has exhibited a copy of voter list of 1979 as Exhibit E, but no such document was found in case record for perusal. Lordship, my whole case is style, Lordship, due to not submitting, Lordship, any linkage certificate with my presented further, Lordship. I become foreigner, Lordship.
How do you link with your father?
Lordship, I have annexed those documents in this petition, Lordship.
Let us see.
Lordship. S47, Lordship, Annex 8, Lordship.
Yes.
Lordship, it is a voter list of 1989, Lordship,
Mm.
where my name has been reflected at serial number 73, Lordship.
Mm.
House number 27, Rajab Ali, Lordship, showing my projected for the name Hussain Ali, Lordship, as against my name, Lordship.
Mm.
Again, Lordship, at page number 49, Lordship, this is a certificate issued by Gaon Pradhan of that concerned village, Lordship. Your Lordship, the name of
Page 49.
49, Lordship, is the typing, Lordship, and vernacular is page number 50, Lordship. Your Lordship has been, the Gaon Pradhan has stated that I am the son of represented father Rajab Ali, Lordship. Again, Lordship, at page number 51, Lordship, that is a typing portion, Lordship. It is a Lordship Jamabandi of my land documents which I have exhibited as Exhibit B and which is duly proof, Lordship, by DW3, one official sub-register, Lordship. And it is the Jamabandi of that land documents, Lordship, where my name has been reflected at serial number 10 of that Jamabandi, Rajab Ali, showing my further name is projected for the Hussain Ali, Lordship.
Where is that? Where is that?
So these are the enough documents, Lordship, which
No.
Lordship.
Where is that? Rajawali?
Lordship at 10, Lordship, serial number 10. Lordship is a vernacular portion as page number 53, Lordship.
There's a problem. We can't read this.
Lordship at typing portion at 51, Lordship.
Oh, 51, there's no mention of your father.
Yes, there is, Lordship, at 10, Lordship.
Hmm?
At 10, Lordship, serial number, Lordship.
No, page 51 is annexure 10, correct?
Lordship. Annex 10, Lordship.
Where's your name? Rajawali.
Rajab Ali, Lordship.
Where's your father's name?
Hussain Ali, Lordship.
Where's that?
It is, Lordship, low down, Lordship.
Okay, Rajawali.
Lordship.
Okay. This has been proved. This
It
was
has-
proved.
It was not proof, Lordship.
It's
Because I have
proved.
not submitted these documents before the learned Lordship member of the FT Tribunal, Lordship.
Mm.
Because, Lordship, I have submitted voter list of 89 to my youngest council, Lordship.
Mm.
But it was mentioned in the written statement also.
This was also exhibited, voter list of 1989.
No, Lordship. No, I have
Then-
I have submitted, Lordship, that 89 documents to my youngest council, Lordship.
Mm.
But what happened? He misnomered the act paragraph number, Lordship. That uh, Fourteen, Lordship.
Hmm?
Operating part, the 14, Lordship of this petition. I have
14.
mentioned 14, Lordship. Page number 9, Lordship. Paragraph 14, Lordship.
Yes.
That the petitioner humbly states that though in the evidence of the petitioner, the voter list of 1989 is mentioned and the petitioner also handed over the same to the youngest council of the petitioner. And accordingly, the youngest council also exhibited the same in the chief of the petitioner. But mistakenly, the youngest council of the petitioner misnomered the voter list as the voter list of 1979. And unfortunately, the same has been misplaced from the record of the tribunal, and the learned tribunal could not find out the said voter list on record, Lordship.
Let's see the tribunal's opinion again. Where was that opinion?
Forty-five, Lordship.
This is 1979. But here you are talking about 1989.
Yes,
Isn't it?
89. It was,
Which annexure 8 is 1989 voter list.
I have, Lordship, handed over 89, Lordship.
Mm.
But the youngest council of the lower tribunal, Lordship, has mentioned it as 1979.
Okay.
And the tribunal has stated that, Lordship, it was not found in record, Lordship.
Mm.
Is mentioned in the impugn judgment, Lordship.
Mm.
Lordship, at paragraph number 45, Lordship.
Mm.
Lordship, I have everything, Lordship, with my position, Lordship, and which I have already handed over to my youngest council, Lordship.
Yes, Shama.
Lordship. Eh, Regarding lordship, he has only produced 1989 voter list. And regarding lordship, land document. Lordship, it is lordship in the year 1976 lordship. The Hassan Ali's names was mutated lordship in Harness. And it is not by way of inheritance lordship. So this land document will not help the petitioner lordship to prove his citizenship.
No, whatever it is, the tribunal did not consider this land, land document as well as the 1989 voter list.
Yes, sir.
Land document was not exhibited.
Not
It was
exhibited.
not
exhibited.
One land document.
And 1989 voter list also was not exhibited.
Not exhibited.
So let them exhibit.
Lordship.
My lord, this is a case, my lord, this case has been initiated, my lord, this case was initiated long back. There was a procedure, my lord, followed in the tribunal. What prohibited them to not to produce those documents? My lord, these are the cases, my lord, which are sensitive in nature. My lord, these are the, in fact, I'm not, in fact, I was not supposed to say this, my lord. They manufacture some documents in later stages, produces before this honorable court. My lord, this cannot be accepted, my lord. My submission is that once the procedure was there, one who has prohibited them from exhibiting those documents at the time of trial, man. Once the trial is completed, my lord, at this stage in the High Court, they bring some documents. My lord, we cannot go see those documents because these documents has to be, my lord, has to be exhibited in the proceeding itself.
According to the petitioner, that he has handed over the document.
My lord, this
Learned Council did not.
I understand, my lord. These are the arguments made in each and every case, almost each and every case. My lord, let the advocate be party. What is the, my lord, where is the authenticity of that statement? Let him make party, the advocate make up
Let us see
whether
that-
it was
that part.
submitted to him or not. My lord, these are the excuses taken in the later stages, my lord.
Lordship, if lordship.
Each and every stage they develop the cases, my lord, and press this point. Because this is not a issue, my lord, on particular single issue, my lord. This is
Where is the original copy of this 1989 voter list?
It is with my hand, lordship, not now my position, lordship, with my client, lordship, with the petitioner, lordship, itself, lordship. The original is lordship.
And the Jamabandi? Jamabandi
Jamapati, it's the lordship, it is,
is a certified
is
true
the-
copy.
yes, lordship. Here it is, lordship.
Where?
Here, lordship. Certificate copy, lordship.
How do you find out that it is a certified true copy?
This was obtained on 1/10/2023.
The latest is lordship.
And he said, my lord, my learned friend has said
10/1,
No, it's not
2023.
79.
10/1/2023. After the
When was the order passed?
order was
22
passed,
lordship.
not 20.
Hmm.
Order is opinion of the court was made of 2019. Opinion to
22 lordship, date of order
2022.
lordship. 4th May 2022 lordship, date of judgment lordship. Hmm.
4th May 2022.
Lordship,
And that means you got a Jamabandi after the judgment.
lordship, because lordship,
Then
but the 89 lordship, I have submitted lordship. Regarding the 89 voter list lordship, I have
only
submitted
the 89 voter list you submitted.
lordship.
Jamabandi. you-
Jamabandi, I have later on, I have collected lordship from the concerned circle office lordship. And lordship, produced lordship 41 of the CPC lordship. 27, rule 27 lordship,
Oh.
which permits lordship to produce some evidence or some documents, relevant documents at later stage, even at the appellant stage also lordship. Lordship,
It's not
see,
the appellate court, my lord.
lordship, I'm lordship, I'm relying on judgment lordship. Judgment of this honorable court lordship. Hyder Ali lordship versus Union of India lordship.
You've got only one copy.
Lordship,
You have only one copy.
No, I have lordship. At page paragraph number 29, lordship.
Come. Yeah. What? In one copy. Para 29 read it.
29, lordship. Paragraph number 29, lordship. From the above, what is important to notice that the Foreigners Tribunal constituted under the Foreigners Tribunal's Order 1964 merely provides a proceeding a reasonable opportunity for making a representation and producing evidence in support of his case before the tribunal. And as such, normally the rules of pleadings, including the written statement as provided under the CPC, are not applicable. As a corollary, the principles contained in the CPC relating to the scope of written statement and limitation placed thereon cannot be strictly applied in the proceeding before the tribunal, though the principles may generally be applied. In fact, all opportunities should be given to a proceeding to enable him to produce all such documents which come to his possession, even at later stage also, to substantiate his claim that he is an Indian. No pedantic view should be taken if there was been some delay or if the same is not mentioned in the written statement. Even under the scheme of the CPC, the right to file any document at a later stage, even if at the appellant stage, is always there, subject to leave of the court, and if such documents are relevant and highly necessary and could not be produced earlier after exercise of due diligence, lordship. A White Order 41, Rule 27 CPC, lordship. Again, lordship,
I'm very on that point, madam. If they want to submit a new documents, they have to take the leave of the tribunal that we want to submit these documents, and that document has to be, my lord, it has to be that it should not be
Tribunal has
obtained
already
even
passed
after
the order, Mr. Payeng. Tribunal has already passed orders.
That's why, my lord. That's why at this stage they cannot.
Why not?
This is not the appellate. This is not the appeal, my lord. This is in, my lord, your lordship. This is a, my lord, there is a tribunal, my lord, as your lordship has seen. There are central administrative tribunals. There are, my lord, other tribunals. This is not a, my lord, normal read code. There are tribunals. These are the opinions coming after a tribunal, my lord. Tribunal has given their opinion. My lord, can we, your lordship, we accept the new documents in this honorable court after a CAT has passed an order, because CAT has appreciated everything, my lord. This is similar to that, my lord. One opinion has been. All the documents have been.
Section 9 of the burden of proof on me, lordship, the procedure.
Yeah, that's why the burden was on
So,
him.
lordship,
And what, my lord, it was, is it after due diligence they could not produce the documents? This was obtained only after, my lord, the opinion order is passed, opinion is passed.
Read this para 29, Mr. Payeng.
And my lord, we have, my lord, contrary judgment of this.
You are going against this para 29.
Yes, ma'am. Para 29. From the above, it important noted that the foreigners tribunals constituted under the foreigners segment, so it provides procedure to reasonable opportunity to make representation and providing the, as such, normally the pleadings included in the written statement as provided under. That is true, my lord. They are given representation. As a corollary, principles contained under CPC relating to the scope of written statement and limitation period there cannot be strictly applied. That is, we are not saying that, my lord. In fact, all opportunities should be given to the proceeding to enable him to produce all such documents which come to his possession even after a later stage. Also, to substitute his claim that he is an Indian. No pedantic view should be taken if there has been some delay or if same is not mentioned in the written statement. Even under the scheme of CPC, the right to file document at later stage, even if at the appellate stage, is always there, subject to leave of the court. Whether they have taken leave of this court.
Subject to leave of the appellate court.
Yes. Subject to leave of the court. And if such documents are relevant and highly necessary, could not be produced earlier after exercise of due diligence.
Yes.
These are the things, my lord. First of all, if suppose, my lord, they want to file a documents before this honorable court, they have to take a leave from this honorable court. First of all, then only they can file it.
So
Without
that's why
taking
they're trying to take the leave of this court by annexing this copy in this writ
My lord,
petition,
this
saying that they'd like to produce this before a tribunal.
no leave petition is, my lord, application. There
This
is
is
no leave.
passed, you know, in which case this order was passed?
This is in, my lord, foreigners tribunal.
Then
Yes.
Yes. This is in FD cases, my lord.
continue reading.
Yes. Thus, if the proceeding is able to make out a case for filing documents at later stage, the same cannot be denied and no adverse inference can be drawn. Similarly, if any fact is introduced at the time of adducing evidence, though the same is not mentioned in the written statement, no exception can be made. It cannot be said that impugnment of adverse inference accordingly taken thereof. This is in the evidence stage.
Read on, read on.
Non-mentioning of any person or fact or document in the written statement, if mentioned later, cannot be said to cause any surprise or prejudice to the state so as to ignore such fact, new fact or document. In any event, liberty is always with the state to review any evidence after the proceeding has completed adducing evidence. We have also noted that witnesses who adduced evidence are cross-examined by the state, and as such, if such deposition cannot be taken during the cross-examination, no adverse inference can be drawn against the petition.
Para 30.
Para 30. Various so and so, the opinion of the tribunal quoted above, my lord, indicates that facts that so and so, Harmuz Ali, father has 3 brothers, namely so and so, so and so, and so and so, and 2 sisters, namely so and so, so and so, was brought only during the cross-examination. The disclosure does not in any way, in our view, check the credibility of the evidence of the proceeding merely because the same was not disclosed in the written statement or in its evidence in chief. On the contrary, this disclosure forfeits his evidence and shows the truthfulness of the witness by not hiding any relationship. This disclosure of this information does not contradict any previous statement, for it was never stated by the petitioner nor his father that his father did not have any other siblings. So my submission is para 29, my lord, whatever it is, my lord, the lordship will see. Para 29, my lord.
35 is also relevant, Lordship, paragraph number. Yes, then, fine, the judgment. Lordship, paragraph number 35 is also relevant, Lordship. May I read, Lordship, 35? As regards civil proceeding, the question of drawing adverse interference will come into play when there is a specific direction by the court to produce certain documents, or when it has been shown that the party is in exclusive possession of certain documents which are relevant to the issue or omission of its production, would directly establish the case of the other side. It was thus held by the Honorable Supreme Court in Union of India versus Ibrahim Uddin, 2012, 8 SSC 148 as follows. Thus, in view of the above, the law on the issue can be summarized to the effect that the issue of drawing adverse interference is required to be decided by the court, taking into consideration the pleading of the parties, and by deciding whether any documents, evidence withheld has any relevance at all, or omission of its production would directly establish the case of the other side. The court cannot lose sight of the fact that the burden of proof is on the party which makes a factual avowal. The court has to consider further as to whether the other side could file interrogatories or apply for inspection and production of the documents, except as is required under Order 11 CPC. Conduct and diligence of the other party is also of the permanent importance. Presumption of adverse interference for non-production of evidence is always optional and a relevant factor to be considered in the background of the facts involved in the case. Existence of some other circumstances may justify non-production of such documents on some reasonable grounds. In case one party has asked the court to direct the other side to produce the document and the other side failed to comply with the court's order, the court may be justified in drawing the adverse interference. All the pros and cons must be examined before the adverse interference is drawn. Such presumption is permissible if other larger evidence is shown to the country. Now, Lordship, case number 16 of the my writ petition, Lordship. Here, Lordship, at paragraph number 12, Lordship, it has mentioned that the parents' name of opposite party and his brother's names are recorded in the voter list of 1989. It has mentioned in the paragraph number 12 in the written statement. Even, Lordship, in evidence in chief of DW1, Lordship, same thing, Lordship, at paragraph number 12, I have mentioned, Lordship, that my parents' name at paragraph 25, Lordship. That is my evidence in chief, Lordship.
Page
25, Lordship. The Varnicula, Lordship. Paragraph number 12, Lordship. That my parents' name and also my name is recorded in the voter list of 1989. In the voter list of 89, my parental uncle names are also recorded. That means I have exercised my due diligence, Lordship, to submit my documents to hand over my documents to the engaged counsel. It is very much clear, Lordship, from the written statement and from the evidence in chief, Lordship. So, Lordship, now, Lordship, bound by situation, Lordship, without any guilty on my part, Lordship, I have been declared as a foreigner, Lordship. So, Lordship, I have produced 1989 documents, my relevant other documents, Lordship, before this honorable court, to convince this honorable court. Yes, I have some linkage documents which might project it further, Lordship, to show that I am Indian, Lordship. So this is my humble intention, remand my case, Lordship, with due respect, Lordship, and Lordship give me a liberty to adduce those documents before the honorable trial court, Lordship, tribunal, so that I can establish my linkage with my projected further, Lordship. This is my humble prayer, Lordship.
yes, fine.
Before coming to the matter, this, as my learned friend has relying. Now the issue is mirrored 1989 voter list, one is Jamabandi. He indicated the 1989 voter list. It's indicated the 1989 voter list in WS, whatever manner it is. But there is no indication of any malad the Jamabandi of 2022, 23, which is obtained after the malad opinion is passed. So that cannot be accepted. Second thing, my lord, regarding that, as is my lord, well, my lord, this case, my lord, the Hyder Ali, it's a in this case, my lord, the numbers of judgment of this honorable court was not considered because there are other judgment of this honorable court. I can rely, my lord, this 2021 1 GLT, my lord, 799. Here it is says how to exhibit the documents, my lord, in the letter is this because there are procedures in the CPC, there are procedures, my lord, laid down. So that has to be followed. Without following that procedure, my lord, the documents cannot be exhibited in the letter state.
In the foreigners tribunal,
Yes.
only the spirit is followed.
The spirit is followed. But my lord, we have numbers of judgments following this that you have to exhibit the documents. My lord, we have numbers of judgment. I can produce, my lord, numbers of judgment. If your lordship wants to see, my lord, I have numbers of judgment. Where this honorable court has numbers of occasions says, my lord, you have to plead everything in the WS. Then you have to prove those things.
That was pleaded, 89 was pleaded,
No, that's why, my lord. Then, my lord,
79 also was pleaded.
79, 89 is pleaded. I'm coming to that.
No, 79 is exhibited. That
79 is
that-
exhibited,
that-
89 was, yes,
That exhibit was not considered by the tribunal
how-
because it was not available on the court.
yes, my lord. Secondly,
Now,
my lord,
how was an exhibit not available on the court?
my lord, what it is their mistake they may have committed. They have, my lord, what my learned friend is saying. That's why I said, my lord, let the advocates be party because what he is saying, I have handed over, but he did not produce. It is not the-
Whatever it is in the WS,
Yes.
3/79,
Yes,
89 is mentioned.
89 is mentioned.
Give her the liberty to approach by
Only
producing
that
89
89 voter list.
89 voter
I'm,
list.
if they want to, my lord, rely on the 89, I have no problem. But they cannot rely the, my lord, whose documents, which is obtained after the opinion.
Yes,
So
plus
Doc-
79 also.
79, 89, what is, my lord, pleaded? That may be exhibited. It's my lord, though it is my submission, it may not be taken as a precedent, but for the ends of justice, it may be exhibited. It may be examined. I have no problem on that. But my lord, the post documents which is obtained after the opinion is passed, that cannot be, my lord, accepted.
That's what I'm saying. I'm not talking on the
Yes.
Jamawandi, but on the
79, 89 maybe.
79, 89 voter list. The petitioner has mentioned in his written
That may
statement.
be examined to that aspect.
Let that be examined.
Yes, only those two voter lists, my lord, 79, 89.
Lordship, lordship. It has been
Heard MS
G. Bora, lordship.
G. Bora Leni counsel for the petition. Also heard Mr. MS L. Devi. For the respond number 1.
Yes. That's coming.
CGS for the respond number 1. Mr. J. Payal and its standing council FP. Correspondence 2,
3 and 7, my lord. 2 will be election commission.
2, 3, and 7.
3 and 7, my lord. We are appearing for 3 and 7.
Oh, the Mr.
He taking, my lord.
Yeah, I read the standing council is here. Correspond number 2
And 4.
and 4. And
5
Mr.
also.
G. Bayang, 2, 4, and 5. And Mr. J. Bayang, and standing council FT for respond number
3 and 7.
3 and 7. And Mr. A. Sharma, P. Sharma, then an additional senior government for the respond number 6. Stop. For on a reference of the Superintendent of Police within bracket B. Now go. Under the Foreigners Act of 1946. Expressing doubt about the citizenship of the petitioner of the proceeding. FT case number 145/2011 was registered in the Foreigners Tribunal second within bracket second. Now go. Stop. Notice was issued to the petitioner. A draft notice was issued to the petitioner. And on receipt of notice, the petitioner appeared before the tribunal and contested the reference by filing written statement stating that he is not a foreigner as alleged by the not a foreigner as alleged. Stop. Well, the petitioner exhibited the voter list of 1965, sell deed of land in the year 1961, sell deed of land in the year 1972, and draft cheetah of the year 1968/1969 as exhibits A, B, C, and D. Stop. Who is that? Your document?
Lordship,
Your father's voters list?
lordship Act 29C, lordship, 1965, lordship. Grandfather name is there, lordship.
29?
29C, lordship, is the vernacular, lordship. 29B is the typing, lordship.
Petitioner relies on the voter list of 1965.
Grandfather name is there, lordship.
which was exhibited as Exhibit A, to show that his father, isn't it,
Grandfather lordship,
grandfather,
lordship,
namely
Ali Mia lordship,
Ali Mia,
lordship.
name appeared at serial number 215 of the set list. So, where's your father's name?
Lordship at 29 E lordship. It is
29?
29 E lordship, typing copy 29 D lordship, the sale deed lordship. It is executed on 13 March 1961 lordship.
29E.
29 D lordship. It's a typing portion lordship. 29 D lordship.
29D.
Lordship.
1 minute. These. The petitioner also relies upon the sale deed of a plot of land which was sold by his father,
Purchase lordship,
which is, sorry, which was purchased by his father, namely Hasan Ali,
lordship,
son of Ali Mia, from
Fateh Ali lordship.
Muhammad Fatih Ali, son of Fuli Mia, in the year 13/3/1961. Stop. And the other one,
Other one is lordship 29 F lordship. It was a 1972 documents lordship. Sale deed
29.
F lordship.
Further reliance is made on the sale deed dated 15/2/1972, wherein his father, namely Hasan Ali, son of Ali Mia, purchased a plot of land from Fatih Ali, Abdul Ali, and Muhammad Foli Mia of village Sunari Bali, Moza Rahagara, PS Samaguri, Chaklabanda, district Nagaur.
Again 29 I lordship. It's a drop sit off Exonian land lordship.
The petitioner also relies on the draft cheetah of the year 1968
69.
oblique 69,
My further name is dear lordship.
wherein
Serial number 2 lordship. Hasan Ali lordship.
at serial number 2, the name of the father of the petitioner, namely Hasan Ali, is recorded. Stop. Para. It is the case of the petitioner that in the written statement filed before the learned tribunal, the petitioner also made reliance on the, where is that?
Voter list of 1989 lordship. At paragraph number 1225 page number lordship.
What is the same thing? It is the case of the. On the voter list of 1989, where the name of his father, where's the voter list?
1989 Lordship.
Yes,
Voter list test Lordship.
where the name of his,
47 Lordship.
where the name of his father,
His
Hasin
father-
Ali, Hasin Ali,
Lordship. Serial number
appears at
70,
serial number
70.
70,
and his name is
and
73.
the name of the petitioner appears at serial number 73. Stop. Further reliance is made, no, further statement is made in the written statement that placing reliance on the 1979 voter list. Where's that voter list, 1979?
1979 is not their Lordship here. I have not annexed it Lordship. Only annexed Lordship 1989.
Where the name of his grandfather, namely
Ali Mia Lordship.
Ali Mia,
Lordship.
appears at serial number 88.
Lordship.
Appears at serial number 88. Stop. Well, it is petitioner has made a statement in the writ petition that he has submitted the voter list of 1979 as well as the 1989 as well as the voter list of 1979 and 1989 to his learned counsel during the proceedings of FT case number 145/2011. However, the counsel of the petitioner could not exhibit the same. Could not exhibit the voter list of 1989. However, the voter list of 1979 was exhibited as Exhibit E. Stop. Para. A perusal of the opinion oblique order dated 4/5/2022 indicates that the voter list of 1979, which was exhibited as Exhibit E, was not found in the case records for perusal of the learned tribunal. Stop. Para. Considering the matter, that the 1979 voter list was exhibited before the learned tribunal as Exhibit E, and that the counsel for the petitioner failed to exhibit the 1989 exhibits, 1989 voter list as an exhibit, despite being stated in the written statement. We are of the opinion that a chance should be given to the petitioner to prove his linkage with his father, namely
Hasan
Hasan
Ali.
Ali, and his grandfather, namely Ali Maya. Stop. A further reading of the opinion dated 4/5/2022 would also indicate that the voter list of 1979, which was exhibited as Exhibit E, was not found on record. Stop. In that view of the matter, the matter is remanded back to the Foreigners Tribunal second now to permit the petitioner oblique proceeding to exhibit the 1979 voter list as well as the 1989 voter list of which village?
Lordship. Your Lordship, Moja Rangakara, it's a Kendra name is there, the Sonar Bali LP School, Lordship, Sonar Bali, Lordship.
Huh?
Sonar Bali, Lordship. Sonari Bali, Lordship.
But supposing if we record something wrong, then tribunal may not like to. We'll just say voter list of nineteen
Lordship,
eighty-nine,
Lordship, Lordship.
relied upon by the. So, draft, comma. The learned tribunal shall consider the voter list of 1979 and 1989 and proceed in accordance with law by passing up with orders. Stop. Subpara. Consequently, the opinion oblique order dated 4/5/2022 passed in FT case number 145 of 2011 by the Foreign Tribunal second now is set aside in question. Stop. The petitioner is directed to appear before the Foreigners Tribunal second now when
This, what this, the Honorable Court deems fit, Lordship.
on 3rd of October,
Lordship.
3rd of October 2022. With the aforesaid directions, your petition is expressed.
My lord, may for the time being, kindly see page 48. This is the voter list of 1989, my lord. This is totally false, my lord, statement, because this is not a certified copy. This cannot be exhibited in the trial court.
I never exhibit this thing, Lordship. I will
That's
exhibit
why-
the
that's why,
certified
my lord,
copy, Lordship.
There is no wrong committed, matter. It is out of record and saying my lord, the learned advocate did not committed any error. It is not his fault. If this document cannot be exhibited by my lord advocate.
No, shall exhibit the certified true copy
Certified copy.
of the 1989 and the voter list
So
and
statement that the documents
wherever I
were
said 1989 certified true copy.
Lordship. If you,
statement that documents have been submitted, this is not.
So let's see if they can produce the exhibits. I'm not
Okay.
saying anything about the
Yes.
Jamabandi.
5,
May I please?
Hmm.
In this case, my lord, although my lord report of the CID inquiry is prepared, my lord, it is incomplete because of the FSL report. FSL report is not yet received by the investigating officer. The state circumstances, we need some time, more time.
My lord, the petitioner is not any protection, my lord. The matter is requiring time, my lord. So we may be protected by any interim order.
Okay.
My lord, at this stage, my lord, almost my lord, query is completed. Only we are waiting for the, my lord, FSL report.
Then, my lord,
Your
interim
lordship may
protection,
take
what
up
will
this
be?
matter after 10 days or 15 days. My lord, there should not be any interim protection at this
No.
moment.
Let no coercive steps be taken.
Yes, my lord, at
That's
least,
not only, I'm
at
not.
least, my lord, that
talking-
protection.
But Mr. A.K. Shikdal and.
A.R. Shikdal.
A.R. Shikdal and the council for the petition. Stop. Mr.
DK Sharma,
D.K. Sharma Leonard,
additional senior governor.
additional senior government, it submits that the inquiry report is ready. However, due to non-receipt of the FSL report, they are unable to produce the same and prays for 2 weeks time. Stop. Prayers allowed, please the matter after 2 weeks. Till then, no coercive action shall be taken against the petition.
Deeply obliged.
7,
May I please, Lordship?
Yes.
Lordship, kindly peruse the last order of this honorable court. Lordship 17/8/2023,
Oh,
whereby a direction was given to obtain instruction. My lord, this is the second round of litigation before this honorable court. In earlier round of litigation, this honorable court lordship has remanded the matter before to the tribunal with certain observation. That is, your lordship may kindly come to page 82. 82 is the
That you have seen. Paying, you're supposed to
Yes.
finish a report.
My lord, report is not coming, my lord. Let it come after 1 week, my lord. I'll get the report.
till then lordship, no coercive action may be taken. Because
Heard Khan Learned Council for the petition. Mr. J. Paying, then standing council, pays for another 1 week or 2 weeks,
2 weeks, my lord.
pays for 2 weeks time to enable him to produce the report as directed by this court on 17/8/2022. Prayers allowed, please stop to 2 weeks. Till the next returnable date, no coercive action shall be taken.
obliged.
Yes, my lord.
Then admission.
May I plead your lordship, in this case, our last occasion, honorable court passed an order for SP's reports, my lord.
This case, my lord, report is here, my lord. I need some 1 week's time to go through the report, my lord. It's a preliminary report, my lord. I have received it today, my lord.
Okay, heard MS,
L. Wajida, my lord.
L. Wajida. Wajida, Learned Council for the petition. Mr. J. Paying, Learned Standing Council, FP submits that he has received the report. However, as the same is voluminous, he prays for some time to enable him to go to the same. Praise the Lord. List after 2 weeks.
Oblige, your lordship.
11.
Last occasion, my lord, standing council of election department, my lord, took time to produce upward and downward voter list of Tenga, my lord.
Yes.
Here is grandfather name is Haran Ali, my lord,
Hmm.
page 19 and 20. And father name is Hoyu Rahman. Voter
Page?
list. Page 19, my lord, 19.
My lord, I have received the voter list, my lord, because it is submitted by my learned friend. Let me go through this voter list also.
Yes.
My lord. Let it come after 1 week, my lord.
Heard Mr.
Yeah, ma'am.
A. Mohammed, Learned Council for the petition. Mr. T. Begu, Learned Standing Council ECI, has produced the voter list of
66, my lord.
1966,
1979,
1979,
1989,
1989,
1997,
and
1997.
1997. Before this court. In the place, same are placed on the court. Stop. Mr. J. Payam, then standing council FT, prays for some time to enable him to go through the aforesaid water list. Praise a lot. List after
After 10 days, my lord.
2 weeks.
12.
My lord. Sometime may be granted, my lord, to produce some more documents, my lord.
What document?
My lord. Land Jamabandi copy, my lord, already applied. my lord.
This issue,
তোমাকে বিস্তার দিয়ে নেই?
Mr. A. Mohammed, Learned Council for the petitioner. Prays for some more time to enable him to place some documents before this court. Praise a lot. List after
2 weeks, my lord.
2 weeks.
Complete.
13.
May it please your lordship. Lordship, here is the direction given to the petitioner to produce the lordship ration card lordship. Now lordship, this petitioner husband is very serious lordship. Now she requires some time to place that ration card lordship. May I pray lordship, this matter will be come up after 3 weeks lordship. In the meantime, she could procure that ration card lordship. Otherwise lordship, other document I have annexed and the LCR has their lordship, the original documents are their lordship.
Okay. Mr.
B. Chowdhury lordship.
P. Chowdhury, Learned Counsel.
B.
for the-
Chowdhury.
B. Chowdhury, Learned Counsel for the petition. Praise for,
Placing the ration card lordship,
how much time you want?
3 weeks required lordship. It's from
Yes,
West
for
Bengal.
3 weeks time to enable him to produce the original Russian card in respect of the petition. Praise allowed, list of the 3 weeks.
Highly obliged.
14.
Password for the timing.
Hmm?
Time password for the timing. मतलब. Materials to compensation, not paying compensation.
Who's appealing?
My lord, in this case, my
I
lord,
second.
charge sheet
Last
has
year-
already been given against my lord, that's number
Uh,
7. And Chabar. And,
Government was supposed to pay some amount under the scheme.
compensation part is concerned, my lord, how can it at this stage, my lord, that can be decided, my lord, determined? Because, my lord, since my lord, charge sheet has been given to the officer in charge. And if, my lord, he found guilty after, my lord, proceeding, in the said circumstances only, my lord, the question of payment of compensation will arise. Or else by issuance of this charge sheet, my lord, other payer of the writ petition in the instant writ petition has been taken care of.
Last order, kindly see the last orders passed by the
Possibility of.
Yes. Have you got a copy of this?
My lord, I can give you. Arun, I put it in there.
My lord, the minor boy, my lord, he sustained injuries on the police custody. At the point of time, my lord, he was a minor. He could not have been, my lord, kept in the police custody. But violating all the norms, the private respondent here in my lord, he has kept the minor boy in the police custody, and resultantly, my lord, he has become physically incapacitated. And this honorable court also, my lord, on several occasions, my lord, has directed the authorities for his treatment, and his treatment is still going on, my lord, since 2016. He is still under treatment. He has not recovered fully till date, my lord. And my lord, as it is succeeded, the case has also been succeeded against the private respondent here in my lord. And from that, my lord, it can be presumed that the minor boy sustained injury from in the police custody itself. So, my lord, adequate compensation may be granted to the petitioner so that he can live his life, my lord, without any. Otherwise, my lord, he cannot do anything. He is bedridden since 2016.
What is it?
Since 2016, my lord, he is bedridden.
2016.
Yes, my lord.
How old is the
Present at that point of time, my lord, he was, my lord, less than 16 at that point of time, and now, my lord, 2016 to around 22, my lord.
He's bedridden?
Yes, ma'am.
I am for the care department. Last medical report that we submitted earlier. That report, Lordship, it shows that he is mentally not fit,
Mentally not fit.
mentally not fit. Lordship, it is
We-
allowed to.
It is.
As per our court order, this is the last report. Already
The report itself has been reflected that his, my lord, mental illness also, my lord, came from the shock he received during the, my lord, police custody. Paragraph 2 of the report, my lord.
How about the result of the blood investigation? No, it says that blood investigation was advised, the reports of which are awaited. You get a copy? Get an updated.
Yes, I given to the.
That can be
That
done.
report I
One more
think
thing, my lord, let the victim be produced before the court, my lord, so that lordship.
No, when
direct with
the
victim
when the
also, my lord.
victim is unable to move,
Yes, he
why
cannot
should we
move,
trouble him by come before the
because
court?
the for physical, my lord, physical assessment of the victim, my lord, lordship may.
Why should we trouble him, give him trouble by coming him, bring him before the court?
Yes,
He's unable to move, he's bedridden,
Yes,
isn't
my
it?
lord.
It will be big trouble for the family members as well as for the victim boy.
That is true.
We're not saying that we don't believe you. What, if you say that he's bedridden, but bringing him to court will be difficult. It will be totally inhuman on the part of the court to call for the victim to see whether he's bedridden.
Yes, my lord. since 2016, a minor boy was my lord, kept in police custody. He was mercilessly detained. That has been admitted by the police itself. That he was beaten up by the private respondent.
That record is here.
Yes.
Who's the petitioner?
Mother of the victim boy, my lord. At the time of filing the petition, my lord, he was a minor. My lord.
When can you submit the report?
First of July, August.
August.
And he has been discharged.
25, 7.
That is what-
Oh, he has been discharged.
Yes. And the Honorable Court direct the SP to admit him.
In the hospital.
Yes,
After that, he was discharged.
yes.
Or he's still in the hospital.
No, he is discharged. He has been discharged. SP. Yeah. Because directed SP to.
So you're at home now.
Yes, he's at home now. But my lord, treatment is going on as per the prescription of the doctors of the medical
Oh.
college hospital, my lord. And he is on medication, my lord.
He's on medication. Then there's no point in calling for a medical report. This stage. Yes, so you want to proceed with the matter?
My lord, my humble submission before your lordship, my lord. Since we have, my lord, issued a search sheet against the respondent number 7, who is the officer in charge at that point of time. And
That is a different thing, Mr.
but-
Sharma.
my lord,
That is a different thing. This with regard to compensation.
so for my lord, a part of payment of compensation is my lord concern. My humble submission, my lord, until and unless it is established by the
Law of torts.
search sheet, it is substituted against the respondent number 7. My lord,
That
if
is a
my lord
different
is
thing.
guilty,
That is a different issue now.
my lord,
Here's a case of compensation. You're liable for the action of your employees.
Also, my lord, against the respondent number 7, my lord, the authority has not taken any steps, my lord. Though the police case has been registered as per the instruction of this criminal court, search sheeted, but departmental proceeding has not been initiated against him, my lord. No departmental proceeding has been initiated.
since
against
my
him.
lord, charge sheet has been issued against him, my lord.
It is established that, my lord, he has beaten up the my lord, victim boy. As per their statement, my lord, their report. But no.
That we'll see later on. Are we ready to proceed with the case or you want a different date? That's what we want.
Lordship will fix another date, my lord. For payment of compensation part is concerned, my lord. And in fact, my lord, medical report shows that, my lord, there are no such, my lord. Whatever, my lord, my learned friend submitted, my lord, medical report says, my lord, that on 14/6/2023, his condition was improved. Lordship may kindly fix another date. I will establish, my lord, this is
It's
not.
not a question of his case is improving.
My lord.
It's a question of a juvenile being kept in for 3 days in the police station and being beaten up.
Lordship may
Leading to his-
Lordship may kindly fix another date, my lord. On that date, my lord, this is a letter for, my lord, that search sheet has been submitted. I will, my lord, collect the copy of the search sheet, which is very much required to, my lord, Arguta case.
Okay.
On the last occasion, my lord, the learned additional advocate general, he made a submission that compensation may be granted to the victim boy, my lord, as per notification dated 1st of February 2019. And my lord, as per this notification, though there is no column for, my lord, the victims under police custody, but the victims of lynching and mob violence, my lord, against that, my lord, there is a minimum of 7 lakhs compensation is, my lord, there, that notification. So that notification may also have been submitted before lordship by the Planet Additional Advocate
That
General.
we have not seen.
এখন আছে নাকি? মানে under police custody এখন নাই। বেলেগ address আছে, সেটা হতে লাগে যে সাধারণ সেটা হচ্ছে দিয়ে দিচ্ছে সেখান দিয়ে অ্যাটাক হবে।
Okay, let Mr. I cycle and consult with the petition. Stop. On request made by Mr. D.K. Shamal and the additional senior government. Please the matter after
2 weeks, man.
2 weeks.
Fix a date, my lord.
Just the matter again on. This one. 29.
Obliged.
Obliged, my lord.
15.
Yeah,
Yes, Lordship, kindly see the last date order 16/8/23.
Yes, any report?
No lordship, not yet received lordship. In 2 weeks time may be allowed.
Okay, Mr.
AT Sarkar on behalf of S. Pator.
Third MS 80 circle and a council for the petitioner. Mr. G. Shamal and standing council FT. Place for 2 weeks time to enable him to produce the report as directed by this court on 16/8/2023. Place allowed list after 2 weeks.
Obliged.
16.
Okay.
And kindly peruse the last order dated 16/8/2023.
My lord, need some more time for produce for Utalis 1979.
19?
Or 97.
Okay, but M. Khan learned it. On request made by D. Bekul and standing council is here. List the matter after
2 weeks.
2 weeks.
17.
May it please your Lordship.
Uh,
Lordship, on last occasion, Lordship, this honorable court directed to produce the school.
Yes, school register,
Lordship, I need some time to produce the
third MS,
H. Ahmed,
H. Ahmed and the council for petition. MS,
B. Decca.
B. Decca, then it's standing council, school education department. Place for some more time to enable her to produce the admission register as directed by this court on 10/8/2023. List after
After 2 weeks.
2 weeks.
Okay. Obliged.
18.
Yes.
May I please yourselves? Grandfather name is Abdul Rahman and father name is Nur Hussain Nur Muhammad Malik. Voter list of 1966 and 1970, my lord. Page 21, my lord.
You are directed to produce the order of the circle officer
Yes, circle officer. my lord.
by
Last,
which Ellen in respect of the
uh,
Jamapandi of village Jarmari
yes, Charmari, my lord.
was mutated in favor of
The Nur Hussain, my lord.
Nur Hussain. You have a copy?
Here is my lord, Jamabundi copy is here, my lord.
No.
But when the name of the father, who is dead, my lord, that part.
You are supposed to produce the order of the circle officer.
Circle officer, my lord. I have already communicated to the petitioner, my lord,
Hmm.
to produce the order of the circle officer, my lord, yet
Hmm.
to be received, my lord.
You want some time?
Yes.
Mr. H. Ahmed.
AM, Ahmed.
A.M. Ahmed. Learners counsel for the petitioner press for some time to enable the petitioner to produce the order of the circle officer as directed by this court on 21/8/2023. Please allowed list after
After 2 weeks.
2 weeks.
19.
May it please your lord.
Hmm.
My lord, the order impugned is at page 38. The petitioner produced, my lord, a photocopy of the voter list, then certified copy of voter list of 66, and the linkage certificate issued by the Gaon Bura and the marriage link certificate. Page 39, your lordship will find exhibit 1, 3, 4, 5, and 6. These were discussed. In exhibit 3, it was said that it is a private document. Exhibit 4, it is also discussed that it is a private document. And my lord, at page 40, your lordship will find one Santosh Rai adduced evidence in this case, in his evidence, that the OP is his sister. Court said that I have failed to show the linkage between the persons who I have declared to be my parents. As my lord, in the written statement, your lordship will find at page 24. On the deposition also I have stated, page 24, father's name is Jitendra Rai, mother's name is Torubala, my grandfather's name is Musaram, my grandfather and grandfather has casted votes in Nagamati LSC, Mangoldo in the year 1966. But the court held because these are private documents, the contents have not been proved, so I have failed to produce the linkage. My submission before your lordship is this. Once Santosh Rai has placed his evidence saying that the petitioner is the sister. My lord, court held because section 74 Evidence Act says about public document, 75 is private document. To prove a private document, 62 on the Evidence Act shows that the originally placed, it will prove the contents of the document. And my lord, my submission before your lordship is the trial court failed to see section 50 of the Evidence Act, where the court has to frame an opinion as regards the relationship between the parents and the family members. If one of the family members, if I can take your lordship to section 50, my lord, 50 of the Evidence Act. Opinion on relationship when relevant. When the court, may I read it slowly, man?
1 minute.
Section 50.
Yes.
My lord, when the court has to form an opinion as to the relationship one person to another,
the opinion expressed by conduct, comma, as to the existence of such relationship of any person who, as a member of the family or otherwise, has special means of knowledge on the subject is a relevant fact. But here in this judgment, your lordship will find at page 40, one Santosh Rai adduced evidence in this case, and in his evidence stated that the OP is his sister. His father casted vote in 59 and 66. His grandfather casted votes in 71. He also cast vote of his father, such and such and such. My lord, here the court has failed to place his opinion before in a judgment as to the relationship. Just only by saying that the burden under section 9 is on the petitioner to prove it. My lord, I have placed my documents, the original is as per section 62 of the Evidence Act, the voters list, certified copy, and the original certificate of the Gaon. Then the court has to frame an opinion as to the relationship. By only placing the section 9 saying that the burden is on the person, cannot cast aside all my evidences. I say, my lord, my submission before your lordship, I was able to prove the relationship or the linkage between the parents and the petitioner. But the court failed to take into consideration section 50 of the Evidence Act, for which, my lord, this judgment is bad in law. Because one of the family member who has the knowledge on the relationship has placed his evidence. And on this chapter, the court only on the basis of section 9 of the Foreigners Act has declared that this is he is a foreigner beyond the period. No discussion as such, my lord. And my lord, I would rely on one of these judgment, my lord. 22-4 GLT, page 64. Page 64, my lord. Another submission of my before your lordship, with all humility, my lord. Yes, the trial court has not discussed about the exhibits placed before. The exhibits, to discuss the exhibits, he has to form an opinion as to the relationship. Declare that they are not the parents. There is no opinion as such. My prayer, so this case may be remanded back, give me an opportunity to prove the facts. Golapi Mondal.
No, no, 2020.
The 2022 for GLT, page 64.
It's 64 now to be.
Now to the 22 3 GLT, sorry, 3 GLT, page 64. লিঙ্কেজ টু পোৱা নাই গাঁওবুঢ়া চাৰ্টিফিকেট ডাইৰেক্ট চাৰ্টিফিকেট খুব পোৱা নাই এই খুব পোৱা নাই কিন্তু এটা বস্তু হৈছে 52 ওপেনিং দেখাই ৰিলেশ্যনশ্বিপ টু ওপেনিং সেকশন 52 চাব লাগিব ওপেনিং
Yes, Shama, are you ready?
No, time. Yeah. Yes, Lordship, but no, Lordship, a Santosh Roy, who has deposed before the tribunal, Lordship, he cannot prove that he is the son of Jatindra Roy. Nowhere, any document has been found, Lordship, where his name appeared along with his father, Lordship. Only statement is not enough, Lordship. In
You could not prove exhibit 3, 4, and 5.
Lord,
Four.
yes, Lord.
The trial court held, my lord, 3 is a private document, 4 is a private document. So these documents were there. I failed to produce because it can be only proved through bringing the persons who have signed it or given the opportunity. On that count also, I pray with your lordship for the ends of justice, where the documents are there, I may be given an opportunity so that I can prove my documents. My lord. The documents are there. It's not that documents were not there. Contents can only be proved by under section 61 and 62 of Evidence Act. My lord.
No, দেউতা বলবত দেউতা দিয়া মই জি পোৱা আমি ভালকে ভালকে
Yes, Shama.
এটা অসুবিধা রিমান্ডের পঠাই দিলে
If you're not ready, we'll list it some other day.
লর্ডশিপ
But Mr. P.K. Roy Chowdhury on request made by G. Sharma, and then standing counsel. When?
লর্ডশিপ any that yes, as your lordship continue.
Convenient date.
Convenient date, my lord. Maybe after 22nd.
27th?
27th, maybe. Month.
Otherwise, matter may be fixed for hearing lordship.
We'll keep it in the admission stage.
Yes, also.
Good.
20.
Lordship, in this case, I need some time. Lordship, earlier occasion, Lordship directed us to take instruction regarding charge sheet.
Produce the charge sheet, my lord. It was called on, my lord,
What's
21/8.
taking you so long to produce the charge sheet?
Yes, my lord. Yes, they need to produce the copy, my lord.
Lordship, short date may be given, Lordship.
You're Mr. Hart, Mr.
H.R. Ahmed.
H.R. Ahmed, learning counsel for the petitioner, on request made by G. Sharma, then standing on the FT. List the matter after 1 week.
Lordship.
Date may be fixed.
It will come up.
My lord. Obliged.
22.
After 10 days, my lord.
Okay, you are Mr.
Yeah,
On request made by Mahakula Council for the petitioner. This is the matter after 2 weeks.
Publish.
Twenty-three.
In this case, your lordship, as per order dated 26/7/2023, a report was called for from the SP border, your lordship. Isn't that the report?
Yes,
Communication made lordship, but report is not yet received. 1 week time may be allowed.
heard Mr.
PM Khan.
A.M. Khan, learned counsel for the petitioner. Mr. G. Shamal and the standing council, please allowed another 1 week time to produce the report as directed by this court on 26/17/2023. Did I give the time? This chapter? Huh? One.
Twenty-nine of supplementary list order.
We were required to take drastic steps. We had taken the steps. And the Loazima court report would show that for 18 and 19, my lord, perhaps
5, 6,
Hmm?
5, 6, 12, and
for 18 and 19, my lord, the Loazima report is of day before yesterday. If I'm not
11, and
ordered I'll do it. What you will find in the bold part. Furthermore, in respect of the respondent number 18 and 19, it has been stated that per information received from the concerned authority, there are no assistant teacher in the concerned school by the name of the aforesaid respondents. Lordship has the orders.
sorry, which order you are talking, you are reading the Lawazima
Loazima order, my lord, of 11/9/2023.
11/9.
2023, my lord.
Yes,
My lord. The bold part is there, my lord. On the second page, page 2. Last paragraph of the bold part, lordship will find. Furthermore, in respect of the respondents number 18 and 19, it has been stated that as per the information received from the concerned authority, there are no assistant teachers in the concerned schools by the name of the aforesaid respondents. So, my lord, if they are not there in the schools itself, it would not be possible for us to serve now. And if lordship could have the next paragraph, in view of the above, it may be said that the service is completed respondent number 4, 7, 13, 16, and 23. In view of the fact that the respondent number 20 is expired, petitioner may take steps for substitution of legal age. For that, I may have to file an IA, but since we never complied with the order of the Honorable Court, it is, the respondent number 20 was never in our service. So it is again difficult for us to trace out the legal heirs in that respect. The last paragraph, further, it may be mentioned that the aforementioned affidavit is silent regarding service of notice upon the respondents number 5, 6, 12, and 16. Now, my lord, our reports have we have received yesterday. For 5, my lord, 5 has expired, and 6, 12, and 16, again, they are not available in the schools on which they had given their addresses in the writ petition. If they are not available in the schools, whether only known address to us is the address given in the writ petitions. They are not available there. We do not even know how to trace them out. If these teachers had asked for to be taken, to be provincialized into the schools. They are not available on the addresses available in the writ petition. And this is an appeal filed by the state. That is where now my lord, we are stuck up. For those who have been declared to have expired, we have even given the death certificates where we could collect, but others were never in our employment. So now, my lord, once they are not available in those schools itself, do not know how to press them out.
Can you try paper publication?
You can try my lord, yes. That I can try. That I can try.
Mr. R. Majumdar, Learned Counsel for the applicant. Praise for taking substitute service. Upon the respondent number
18,
18, 19,
and 5, 6, 12, and 16.
5, 6, 12, and 16. Correct.
My lord.
So, praise the Lord. The applicant is permitted to publish the notice in 2 local newspapers having wide publication in the state of Assam. Within bracket, 1 in vernacular and 1 in English. Upon the respondent number, that same number you give. Within a period of
2 weeks, my lord.
2 weeks from today, showing the returnable date as we give them a long date,
My lord.
13th October. 13th October 2022. Stop. Thereafter, applicant shall file an affidavit with that effect. List the matter on 13th October.
She would make it 3 weeks for me to take the steps on that I forgot. The assembly is going on, so the office would not be able.
3 weeks. Time.
3 weeks.
3 weeks time is what? 1 week, 2 weeks. So I think the returnable date is
30th November.
that time it will be a holiday. Calendar has changed.
Let's keep it at 2 weeks, no difficulty.
2 weeks.
We'll do it.
Then within the same.
Obliged.
25 of daily leave hearing.
My lord, last time I completed my part of hearing, my lord, only the government side was asked.
Bench has changed.
Argument, my lord. I have completed my part.
Bench to send this. The bench has changed. You have to re-argue again.
That's right. Hearing, I have argued here, my lord. Last order may be seen, my lord. Last order, I was heard. Only when Dharma was to argue on behalf of the state.
That time my bench partner lordship has come in. There's the new bench.
Oh, yeah, it's the, okay,
We have
my
to
lord.
proceed afresh.
That's just, sorry. My lord, there,
But the thing is, whether we have paucity of time. We have just about 20 minutes. Whether you can complete in 20 minutes. So after 2, I'm not sitting. This whole week I'm not sitting up.
I don't think it will be completed for between 20 minutes.
We'll fix a date.
my lord, in this case, this petitioner was.
They
Hmm?
fix that. They do what they-
Okay, my lord.
But Mr. BC Das, let me consult as well as
We
Mr.
could put this into,
G. Sharma, and
sorry.
standing counsel. FT. This is the matter, you know. 25th.
Possible 28. Possible 28.
My lord, will to wait be
28.
Hmm?
28.
No, 25.
28 will be possible, my lord?
28.
Okay, that's.
26.
Sometime may be granted, my lord. A last order, my lord, directed the petitioner to produce the original sale deed of 1967, my lord. And yes, after 2 weeks.
On request made by Mr. H. Ahmed.
A.M. Ahmed.
Oh, A.M. Ahmed. Your name is not here.
Here is my lord, A. Mutin side. Most probably. Yes, sir.
Then is counsel for the petitioner list after
After 2 weeks.
2 weeks.
27.
May I please, Lordship? My lord, matter may be taken after 2 weeks.
On request made by Mr.
M.I. Hussain.
M.I. Hussain, list the matter after 2 weeks.
Obliged.
28.
28 also, my,
Got it.
after 2 weeks.
On request made by Mr. A.M. Ahmed and counsel for the petitioner.
Okay.
After 2 weeks.